Thank you, Chairman. Let me ask unanimous consent to put into the record a letter from over 100 groups dated March 14th, 2017 regarding what they describe as Judge Gorsuch's troubling money and politics record, and a letter from Demos dated March 9th, 2017 urging opposition to Judge Gorsuch's confirmation, and a New York Times article captioned, "Neil Gorsuch has web of ties to secretive billionaire."
Without objection, all three documents will be included.
Thank you. Before we get into that, Judge, let me, since we were talking about separation of powers, could you just reflect on whether the constraint that an appellate court is obliged to take the findings of fact as lower courts have found them and can't indulge in its own fact-finding or fact-making, does that have a separation of powers element to it in terms of constraining the free-range wanderings of a court that could make up its own facts and then go in that direction?
I haven't thought about that, Senator, to be honest with you. I know...
How about the question presented? Should the Supreme Court, in the question presented, try to keep the question narrow to the case presented so that it's not using an expansive question presented to enable itself to wander throughout the legal landscape beyond the constraints of the case?
Senator, it's generally, as you know, on the facts, the practice of an appellate court not to review or overturn the facts of a trial court except in the presence of clear error.
Very rare, yeah.
And that's a very important standard.
Yep.
It may have, I haven't thought about it in separation of powers, but it's a very important principle that I take seriously. I was a trial lawyer for a long time.
And in terms of the constraint to narrow the question, does that have separation of powers overtones as well?
And I give you kind of a similar answer on that, Senator. I don't know about that, but I would say it's an important general practice. Sometimes there are exceptions that a court can and should go beyond a question presented, but it's pretty rare. Usually we stick within, well, we don't have, the questions presented are whatever the parties present to us on an intermediate court. They get to choose. We don't get to choose.
That's part of what separation of powers is about in terms of constraining the judicial branch to actual cases and controversies, correct?
Well, we generally refrain from examining arguments that haven't been adequately developed or made for risk of improvident mistakes.
Now, let me turn to another topic. Let's talk for a minute about money. And in particular, let's talk about dark money. Are you familiar with that term?
In the loosest sense.
How would you describe it in the loosest sense, just to make sure you and I are on the same wavelength?
Senator, as I understand it, you may be referring to money that's not spent by a candidate or a party in connection with...
where you actually don't know who the true source of the money is.
Okay.
Is that a fair enough definition for us to
Sure.
agree on? Okay. Could you let us know first what you know about the campaign that is being run to support your confirmation? There's been a lot of talk about how this is outside of politics and we're above politics, but there's a group that is planning to spend $10 million on TV ads in which their own press release describes as a comprehensive campaign of paid advertising, earned media, research, grassroots activity, and a coalition enterprise, all adding up to the most robust operation in the history of confirmation battles. That sounds pretty political to me, and I'm wondering what you know about that.
I've heard a lot about it, Senator, from you, from others. I've heard a lot about it.
Do you know, what do you know about it?
I know that there is a lot of money being spent in this by, as I understand it, both sides. I think.
Well, I wouldn't leap to that conclusion at this point.
Okay. I know what I've read. I know what I've heard from friends and family and acquaintances. I know what you're saying, what you've just indicated, that there appears to be a lot of money being spent.
Do you know who's spending the money?
Senator, I could speculate based on what I've read and what I've heard, but I don't know individuals were contributing? I don't know that.
Do you know if your friend, Mr. Anschutz, is contributing?
I don't know.
Do you think that it should matter who is contributing? Do you think that there's a public interest in the public knowing who is contributing?
Well, Senator, I think we've got a long tradition from in Buckley versus Vallejo, indicating that this body has robust authority to regulate disclosure.
Yeah, but my question is, do you think there's a public interest
And Senator,
in disclosure of political funds in a democracy? That's, I don't think, a prejudgment. That's just a values proposition, and one of the considerations that you ought to be able to answer without much hesitation.
and Senator, what I'm prepared to say is I recognize that as a matter of First Amendment interests, the Supreme Court has validated the proposition that disclosure serves important functions in a democracy. At the same time, the Supreme Court's also acknowledged that those disclosure functions can sometimes themselves have unintended consequences, as with the NAACP case, which I know you're familiar with, where you can use disclosure as a weapon to try and silence people. And we have a long history in this.
Hardly the case with respect to the dark money operation that is funding this campaign in your favor, is it?
Senator, I'm not prejudging any case. What I am suggesting to you is that there are interests here in this area of First Amendment disclosure. That's what we're talking about,
Yep.
in my mind, generally, okay, that are competing. On the one hand, in order for informed voters and citizens to be able to make decisions, the Supreme Court in Buckley has validated the interest that this body has in regulating disclosure.
And in theory, so did the court in Citizens United.
And in theory, in Citizens United. At the same time, the courts also recognized in NAACP, for example, that disclosure can be used as a weapon to silence voices. And we have a long history of anonymous speech serving valuable functions in this country.
So here's here's a live example right now. We have this $10 million that is being spent on behalf of your confirmation. Do you think, for instance, that we on this panel ought to know who is behind that? And, well, answer that, and then I'll go on to a related question.
Senator, that's a policy question for this body.
Well, it's also a question of disclosure. You could ask right now that as a matter of courtesy, as a matter of respect to the process, that anybody who is funding this should declare themselves so that we can evaluate who is behind this effort.
Senator,
right? That wouldn't be a policy determination. That would be your values determination.
it would be a politics question. And I'm not, with all respect, Senator, going to get involved in politics. And if this body wishes to pass legislation, that's a political question for this body. And there's ample room for this body to pass disclosure laws for dark money or anything else it wishes to, and it can be tested in the courts. So, Senator, with all respect, the ball's in your court.
Do you really think that a Supreme Court that decided Citizens United doesn't get involved in politics?
Senator, I think every justice on the Supreme Court of the United States is a remarkable person trying their level best to apply the law faithfully.
And they
I'm
got
just not
deeply involved in politics, did they not? They changed the entire political environment, the entire political ecosystem with one decision. You must recognize that.
Senator, it's a precedent of the United States Supreme Court. There were thoughtful opinions by justices on both sides.
I didn't say that they weren't thoughtful. I was responding to your question that they don't, your response that they don't get involved in politics. What could be more involved in politics than to open this ocean of dark money that's flooded into our politics?
Senator, what I mean to suggest is that I believe every justice on that court is trying to apply the First Amendment and the laws of this country faithfully. You may disagree with them. Many people do. I understand that. It's hard. Judges make half the people unhappy 100% of the time. That's our job description. And people do criticize judges. I understand your criticism. But I do not question their motives, Senator.
This is a little different. I think you see more like 90% of the public unhappy with Citizens United because they see the problem that it caused in our democracy. And in that case, it wasn't just a question of two parties and you're going to make one of them angry because you decided for the other. This is the Supreme Court operating in its role as the legal constitutional guide to the operation of American democracy. And if they get that wrong, that is a much, much bigger deal, whether their motivations were pure or impure. When or whether they got that wrong is a bigger question than just which party won. Wouldn't you agree?
Senator, if a court errs as a matter of law, there are various remedies. There is a legislative remedy because there's always another law to be passed and another case to test. Every case comes on its own facts with its own record and can be analyzed anew. And then there's the law of precedent, which we've discussed. I wrote this 800-page book on. Makes a great doorstop, gift for Christmas. I cut a really bad deal on royalties.
And another way is for the court to clean up after itself if it's
Yeah,
been wrong.
that's what I'm suggesting. There is a way to do that, right? Precedent is not an inexorable command. And so the court can reverse itself. It happens.
If a question were to come up regarding recusal on the court, how would we know that the partiality question in a recusal matter had been adequately addressed if we did not know who was spending all of this money to get you confirmed? Hypothetically, it could be one individual. Hypothetically, it could be your friend, Mr. Anschutz. We don't know because it's dark money. But if you were to ever find that out, or even if you were to have suspicions, I think in any challenge as to whether recusal was appropriate or not, were that to happen, say, in a lower court, these would be facts that would be noteworthy and that we'd be entitled to have an answer to. So it's kind of odd to be sitting here in a United States Supreme Court nomination hearing with a $10 million spend taking place for you out there in the political world and absolutely no idea who's behind it. Is that any cause of concern to you?
Senator, I'm not sure what the question for me is.
Is it any cause of concern to you that your nomination is the focus of a $10 million political spending effort and we don't know who's behind it?
Senator, there's a lot about the confirmation process today that I regret. A lot.
Yeah?
A lot. When Byron White sat here, it was 90 minutes. He was through this body in 2 weeks, and he smoked cigarettes while he gave his testimony. There's a great deal about this process I regret. I regret putting my family through this.
But to my question.
Senator, the fact of the matter is, it is what it is, and it's this body that makes the laws. And if you wish to have more disclosure, pass a law and a judge will enforce it, Senator.
There are going to be, that's just not, that just doesn't do, Judge Gorsuch. There are going to be questions that you will be asked to decide on the United States Supreme Court that are going to be dependent on the values you bring to this. I don't think you can avoid talking about those values here. You're an expert on antitrust law, correct? You're very good at that.
I wouldn't count myself an expert, Senator.
And when you write about antitrust law, you understand that there are values to which the law should be directed if it's going to be successful. You've written about the values of competition, that the antitrust law should operate in such a way as to maximize and support competition. and that the antitrust laws should be read in such a way as to maximize and support innovation. Those are proper values for a judge applying antitrust law to pursue, are they not?
Senator, a judge applying antitrust law looks to precedent predominantly for guidance as to what
A lower
rule of
judge
decision.
does.
Yes. And so
Supreme
does the
Court's, usually it's a new question, otherwise it wouldn't be there for you.
Senator, respectfully, I disagree. Supreme Court justice is bound by precedent, too.
No, but the question likely presented in the case is one that is new, otherwise it wouldn't be in the Supreme Court. They would not have taken it for review, and it would have been settled at the circuit or at the district judge level, no?
Senator, the precise question may be new, but the notion that precedent wouldn't bring to bear instructions and information on how it should be decided would be mistaken as well.
I guess what I'm saying is that the part of the decision that is guided by precedent is not the part that I'm asking about. The part that I'm asking about is the values determination, and I'm trying to determine if you think that openness with respect to the money that flows around in our democracy in such large numbers right now is a value that is worth pursuing. Is it a touchstone? Is it a lodestar? Or is it just a burden on people's communication?
Okay, I'd refer you again to Buckley versus Vallejo and NAACP.
I'm asking actually you,
And
not,
I'm giving you my answer, Senator, as best I can,
okay.
which is the First Amendment, which I'm sworn to uphold as a judge, contains two competing messages here. On the one hand, it has regularly recognized the rights of this body to legislate in this area if it wishes to do so. If it hasn't done so, with respect, that's not my fault, okay? It's on legislators to legislate. And Buckley recognizes their authority. On the other hand, it has recognized there may be limits when it chills expression, as it did in the NAACP case. And we have to be worried about that because there is room in our democracy.
So if we have to be worried about the chilling of expression, which is a value proposition that you have just enunciated, should we not, am I not also entitled to ask the question about whether we should be worried about the influence of dark money essentially corrupting our politics?
Instead of what I'm
Taking a lot of time to get what I would think would be a fairly simple answer.
Well, I'm sorry, but I don't think this is simple stuff at all, Senator. I think this is hard stuff. And I think you've got First Amendment concerns and precedents, all right, in the area that would have to be considered. We'd have to see what law Congress enacted. I'd then want to go through the full judicial process, Senator. I'd want to read the briefs. I'd want to keep an open mind.
I understand, but you just asserted right here that the value of not chilling speech was something that we should consider, right?
I said the Supreme Court of the United States in NAACP recognized that the First Amendment protections we all as people in this country enjoy
Which is a value that we should consider.
can be chilled.
And
Sometimes.
not chilling is a value that we should consider.
It's a First Amendment right we're talking about, Senator.
And where does an anonymity, let's say $1 billion in anonymous funding into our elections, where does that fit in your, into the values that you bring to this?
In the first instance, Senator, it's for this body to legislate,
Yeah?
and then it would come to court, and a record would be made.
Of course, Citizens United did actually overrule a law that we had written, so that's hardly the be-all and the end-all.
Well, it's a dialogue. It's the separation of powers dialogue that we have in all areas. Congress passes a lawsuit's brought, a record's made, a fact finder makes facts, judges determine the law, a ruling is issued, Congress responds, and the cycle continues. And Senator, that's our history. In this area and so many others, our founders were brilliant. They didn't give me all the power. I don't wear a crown, I wear a robe. They didn't give you all the power.
When it
They
comes
divided
to the determination to state what the law is, particularly in constitutional matters, they actually did give the Supreme Court the power. And that's why it's important to us to ask these questions now before you go on to the Supreme Court, and we have no accountability left. And so the values that you bring to that in those areas where you're not just implementing Congress's will, but are bringing your own values to the constitutional document that we treasure, that is why I think these questions are important. Let me ask something slightly different. You said you knew Judge Garland.
I do. I wouldn't claim him as my closest personal friend, but someone whom I admire greatly. And I know.
Would you describe, how would you describe any differences that you may have in judicial philosophy with Chief Judge Garland?
I would leave that for others to characterize. I don't like it when people characterize me, and I would not prefer to characterize him. He can characterize himself.
What's interesting is that this group sees a huge difference between you that I don't understand. The dark money group that is spending money on your election spent at least $7 million against him getting a hearing and a confirmation here, and indeed produced that result by spending that money. And then now we have $10 million going the other way. That's a $17 million delta. And for the life of me, I'm trying to figure out what they see in you that makes that $17 million delta worth their spending. Do you have any answer to that?
You'd have to ask them.
I can't because I don't know who they are. It's just a front group. There is it's been, I think, fairly and fully documented that there's a small group of billionaires who are working very hard to influence and even to control our democracy. Kochs, Mercers, DeVoses, and yes, Anschutzes. They often network together. They attend planning conferences. They pool their resources. As a candidate, President Trump made fun of the begathon, to use his word, that the Koch brothers run every year to bring candidates to their conference. They set up an array of benign-sounding front groups to both organize and conceal their manipulation of our politics. And Supreme Court justices socialize with this small group. And then they go and they render decisions that give that small group immense political advantage, particularly the ability to hide the political expenditure of their money. And then they go back and socialize some more with that group. And they even speak at the begathon political retreats. Does that look right to you? How, as a judge, do you think, as a justice of the Supreme Court, should you comport yourself in terms of keeping a distance from interests that are before the court?
Senator, I have no information about anything you've just described. I don't know about that.
And wow, because guess what? You're going to be asked to make decisions on the Supreme Court that, if you don't know that, you're going to have a very hard time figuring out how to make the right call. It's a real concern. You know, this is the first Supreme Court in the history of the United States that has nobody on it who's ever run for political office. Ever. And yet it makes these wild leaps like Citizens United that completely deform democracy. And then, I don't know if they don't know what they're doing. I don't know what the motivation is. I don't know. I sure don't know. But I do think it's a concern to be asked to make decisions like that without a real grounding in what's going on around you. Let me ask a little bit just about, to narrow it down more to the judicial branch, what do you think the court's approach should be to the sort of machinery of corporate influence that surrounds the Supreme Court? There are corporate front groups that have been described, I think, very well as the think tank as disguised political weapon that surround the court and constantly pelt it with amicus briefs on behalf of big corporate and industrial interests. At this point, in the 5-4 decisions I listed yesterday, their record is 16-0 at the Supreme Court in terms of helping the corporate interests. So it looks like they're doing really, really well, these frequent flyer corporate front amici. When they turn up at the Supreme Court, should they disclose more about whose interests they represent? Would it be good for the reputation of the Supreme Court and for our democracy if people knew who actually funded them when they turn up?
Senator, to your earlier question, I think I can talk about my record. I'm not a philosopher king, but I can talk about my record. And my record is that in the last 10 years, I don't think there's been a single motion to recuse me. I've tried to be very careful in which cases I hear.
This is
And
Go
I
ahead.
take that very seriously. It's part of my obligation as a judge. I can't claim I'm perfect, but I've tried awful hard, and I haven't had a motion filed against me because I do take seriously the impartiality and the appearance of impartiality. And Senator, all I can say to you is that I commit to maintaining my impartiality as best I can and to recuse where the law suggests I should.
So back to my question about these amicus briefs and not knowing who's behind the front groups who turn up and pelt the court with the briefs.
Senator, there's a
There's a
corporate
rule.
disclosure statement rule, as I recall.
Yeah, but it's not much of a one, because here's what it says. It says that the filers shall identify every person other than the amicus curiae, its members, or its counsel, who made a monetary contribution to fund the preparation or submission of the brief. As you know, the preparation and submission of a brief is not particularly expensive, and the monetary contribution is not ordinarily reported as being the funders of the organization. So if as I understand it, if an organization gives $100 million to a front group and says, go in there and don't put my name on any of this stuff, but this is what I want you to do, as long as the front group then pays for the brief itself, there's no filing that reports who the interest is behind it. And I worry that we have an operation going surrounding the court, that the court itself is actually blind to the true roots of. And should the court not understand what the interests are behind these front groups?
I think that's a very interesting suggestion, and one I will take to heart, Senator. Obviously, this Congress has a role in rulemaking process as well, and there's a rulemaking committee and a Rules Enabling Act process for the lower courts, and the Supreme Court has its own rulemaking process, and I appreciate that information for both functions.
And as a
welcome
Supreme Court
your
justice,
involvement.
you'll also have a role in policing the judiciary as the top court. One of the things that's cropped up is special interest training camps, basically, at lush resorts for lower court judges. As much as 40% of the federal judiciary has gone to these special interest funded training sessions, described by one writer as a cross between Maoist cultural re-education camps and Club Med. There's been a wide array of condemnation of this practice from editorialists of all stripes. And is that something, as a matter of kind of protecting the integrity of the courts, to which the Supreme Court should attend itself?
Well, Senator, I know as a sitting judge, I disclose every trip I take that isn't official business that anybody else pays for.
And to your credit, you went to none of these, as far as I can tell.
Thank you, Senator. I appreciate that acknowledgement. I do go to a lot of moot courts and things like that, and and everything I've done is disclosed. So it is all there. You have all the information.
Yeah. I'll just note that some of the editorializing about this, it creates an egregious ethical conflict of interest bordering on wholly improper out-of-court communication with special interest lobbyists or representatives of people who have filed lawsuits, Another said, it looks like an interest group has put part of the federal judiciary in its saddle. A third said, the conflict is clear and the judge's participation is mind-boggling. And by the way, all of those came from newspapers below the Mason-Dixon line. That's not just Yankee elitists talking. So my time has expired, but I look forward to further rounds, and I appreciate your time with me.
Thank you.